on opposite ends of punctuality there, apparently. All right, so guys, our first speaker is going to be Richard Gladden, and I guess you can look at his bio. I won't read his whole bio there, so we don't take up all that time. But one of the things I find fascinating this year is about how many attorneys we're starting to see show up at our conferences and go, wow, they've come to realize on their own, and we've got two of them in the room here, that what a big problem we've got, and they came to realize on their own, not just necessarily because they have a stake in the game, a family member or themselves or something like that. And those are the folks that always impress me. And attorneys have a lot of ways to give their time, and there's a lot of things they can give their time to that will grow their law firm. However, attacking sex offender issues is not one of those that you can post on our website. Wow, look at what our firm did. We got a bunch of sex offenders off the registry. Yeah, that's probably not going to get them real far. So we really need to appreciate their time and their commitment and for taking us on. And his presentation is going to be on online identifiers in the Constitution as it applies to that, and how we can obviously work to stop that one other constitutional issue in regards to the registry.
Thank you, Lloyd. I've got a mic here. First of all, can everybody hear me? I've got a wireless mic here. I want to make sure that people in the audience as well as people at home can hear me. Welcome. I guess I apologize for not being here sooner. I just kind of got crammed up at the end of the week, but it's certainly wonderful to be here. It's really a privilege. I've had the opportunity to actually be in this room before and speak for two Texas Voices about related issues, but my topic this morning is going to be about what I'm sure most of y'all have heard of, the requirement that people or registrants provide their, quote, online identifiers, end quote. I'm going to kind of canvass a little bit about what the requirement involves, refer to some statutes from some other states to give you the different models that are going around, because different states will enact different kinds of language in that requirement. I'm a criminal defense lawyer, and although I've had a lot of cases dealing with people who kind of got crossways with the authorities because they didn't register timely after they had moved or the things of that nature, Texas is kind of, to some degree, a little bit unusual in that they've delegated to the Texas Department of Public Safety kind of an open-ended catch-all authority to require things that the legislature never expressly did, such as shoe size. So, believe it or not, you're required to update your registration information in Texas when you go to the shoe store and you decide you might need a little more room at the end of your shoe. And you got 7 days to do that, or else you get a felony. At any rate, I've prepared a paper that goes into a little bit more detail. It's in a box at the back of the room. I think it was being handed out as some of y'all came in. If any of y'all don't have it, if you can raise your hand, I think Mary Sue's got some copies where she'll hand them to you. And also, I'm going to try to get this paper posted. It's not real long, but it does give you some references to cases that you can go find and statutes or the citations to the statutes that we're going to discuss. Okay. Everyone, I'm sure, has heard of SORNA, that is the Sex Offender Registration and Notification Act, that was part of the Adam Walsh Child Protection and Safety Act of 2006. What Congress did was kind of in a general way, I'm sure y'all are aware, required kind of base registration elements such as your name, your driver's license, address, date of birth, and then of course they include in registration, the age of your alleged victim or victim if you've been convicted, and things of that nature. When Congress, in that statute, or that federal statute, Congress also, kind of like I mentioned a moment ago, the Texas legislature has delegated to the Texas Department of Public Safety the authority to add additional registration requirements, to require additional information. Congress, in its statute, and SORNA, delegated to the Attorney General of the United States authority to come up with additional requirements that he or she might see fit or appropriate to include or require under the federal statute. In that connection, on July 2nd, 2008, then U.S. Attorney General Michael Mukasey, who was serving under the George W. Bush administration, and you might remember him. Mukasey was the guy that came in kind of unexpectedly after Ashcroft resigned. At any rate, Mukasey actually set out the requirement that people in different states register their online identifiers, and we're going to get into the definition of that in just a second, but he was the one that actually reinforced the requirement that had kind of been inferred as a requirement by Congress that required states, if they wanted to keep their some federal funding, that they would have to enact in their own state laws the requirement that registrants provide that information. Getting to the definitions, actually you're moving too fast. If you can, yeah, there we go. State law definitions. I'm going to have to watch over my shoulder to make sure we're on the same page here. Okay. If you go on to the next page, I've provided 2 or 3 or 4 definitions. I generally have included the Texas definition of online identifiers. A lot of them are pretty similar in that they refer to electronic mail, email, chat, instant messaging, social networking, and other similar types of communications. The cases, I don't address it in this paper in any great detail, but it comes up from time to time, and my clients actually ask me quite frequently whether registering a username and password with a bank would be included as an online identifier. The very few cases, there's not a whole lot of cases that actually have addressed the constitutionality or the meaning of these things, and that's on a national basis. There's about 4 or 5 decisions I'll refer to in this presentation this morning, but I'm only aware of like 1 or 2 that aren't mentioned in this paper that talk about whether that does or does not include accounts set up for banking purposes. There's something, a rule of interpretation of statutes called adjustum generis, which basically means that when you give examples, as these do, of the types of things that are considered online identifiers, you exclude things that are not within that category. So the one case that I can recall that actually addresses that says that online banking accounts where you provide a username and identifier would not be included. And so if you fail to do that, to provide that information within whatever designated time is required by your registering authority, it would not be a violation. If we go to the next page. Arizona actually spells out in its statute that it does not include any social security number, date of birth, or PIN number, although quite frankly, I think probably most registering authorities already have your date of birth. But the general idea is, of course, I imagine probably a lot of you, especially if you're registrants, have probably been limited in your ability to be members of Facebook and MySpace and things of that nature. That's kind of it seems like to me that's kind of the target of these online identifier things, as I'll discuss in a little more detail later. One of the issues that's involved in the constitutionality of this requirement is that people have a constitutional right to anonymous speech. And as I will discuss in a little more detail, courts and the U.S. Supreme Court's recognized it back in the Revolutionary days. It was actually just a standard practice, among other people, Thomas Paine, when he wrote what's known as Common Sense. That name actually was his pseudonym that he used when he published Common Sense, advocating independence from England. And just about everybody that published editorials in the Revolutionary period and for a long time after that, they never used their real names. Sometimes it was kind of commonly understood who they were. But the idea is that true freedom of speech requires, if it's going to be effective, that people be able to express themselves in public forums, and we'll talk a little bit about what that means, without fear of their expressions being prejudged by them being a disfavored group or a disfavored person, or in some cases, and I think it's probably true in the sex offender registration context, that people have a legitimate fear of retaliation. I think we've heard stories about people that have to register, and the consequence of having your residence address as a publicly accessible information. People have legitimate fears if they have to register that you're going to get some wacko somewhere that's going to come out and shoot up the front of your house or whatever. So, as I'll discuss in a little more detail, the right to anonymous speech is something that really is fundamental under the First Amendment. In addition to the definitions of online identifiers, states have, just like they do with changing your residence address or employment address, they have deadlines for registrants to provide their online identifiers. If we could look at, okay. All right, now, one more page. I provided you with some of the examples of the deadlines, and they really are kind of all over the place. North Carolina, if you could hold there. A couple of things I want to point out about how these things are set up is here in the North Carolina statute, it's an after you've established or used an online identifier, after your initial registration where you're required to provide that. It's a question of updating the information. In North Carolina, they require people to notify or register with the authorities within 10 days after they either have established a new identifier or used. This uses actually uses the word obtains or changes to previous. I can't imagine you actually changing a previous identifier. It's more a matter of adding to or using a new identifier. But you've got, North Carolina, you got 10 days, and you have to report to the sheriff of the county where you're registered. And some states, actually, it's kind of interesting, we're going to go through this, but what's critical is some states, and I think probably most of them, require the actual update to be done in person. As we'll see when we discuss one particular case, some states will allow you to update the information by email, which is a lot more convenient. Some states will allow you to update your registering online identifiers by U.S. mail. And of course, generally, most of them require, just like any other registration requirement, they compel you to, within a certain number of days, personally go visit your registering authority and update the information. We can go to the next page. Here's Arizona's deadline, and theirs is very short. And as I'll discuss a little bit later in the paper, it really, I think Arizona is probably would be the easiest target. We're going to talk about some cases around the country that have actually invalidated some of these online identifier statutes for violating the First Amendment, both as to the right to anonymous speech as well as the burden it actually imposes to either chill someone's expression or just overburdening the expression. Arizona's is real interesting in that it's very short, 72 hours, which is, I guess, business days. It excludes weekends and legal holidays. The thing that's really of greatest concern constitutionally is it actually requires that before you use the online identifier, you have to report it. Okay? Now, you know, I'm assuming that probably most of y'all aren't lawyers and you're not familiar with something called prior restraint. Under First Amendment law forever, there's been a real, a prior restraint on speech or publication of newspapers and books and whatever else is the most disfavored form of regulation of speech that exists. Some of you may have heard or recall, if you're my age, something called the Pentagon Papers. And that was where Daniel Ellsberg had, I think they even got movies and stuff about it, was working for a front organization in California and was aware through his high security clearance that the U.S. government was bombing Cambodia at the same time that President Nixon and probably Johnson as well were publicly denying that they were bombing Cambodia. And that was just one of the things that concerned Daniel Ellsberg. And so he used an old-time copier and copied thousands and thousands of pages and turned it over to some newspapers. I think New York Times is probably one. For their publication. When the Nixon administration found out, or maybe found out that it was going to be published, some of this stuff that they considered to be matters of national security, they went to court seeking to enjoin, that is to prohibit the newspaper from publishing that information on national security grounds. The U.S. Supreme Court in an emergency session issued an opinion, I think probably in less than 24 hours, maybe even 48 hours, expressing the fact that that would constitute a prior restraint, and therefore that kind of governmental action is subject to the most extreme scrutiny, because just as a matter of policy, the First Amendment opts to punish people after they've spoken something if it's not protected speech, not prohibit people from speaking without anyone ever knowing whether the speech that was sought to be expressed or uttered was protected or not. And actually in the Pentagon Papers, the Supreme Court said that notwithstanding the claim of national security by the Nixon administration, that the New York Times had a constitutional right to go ahead and publish the Pentagon Papers and inform the American people that their government was lying to them about bombing a country, the country of Cambodia. That's the problem I see, and I don't know who the lawyers are in Arizona that came up with this idea, but the very idea that you can prohibit somebody from going online where they would establish a identifier that prohibits them from doing that until they've gotten pre-clearance or complied with some pre-expression requirement, that is extremely questionable. There are not any cases I've found that are directly challenging or have directly challenged the Arizona statute. I know that they did some amendments to the statute in this last or most recent session of their legislature out there, but they did not fix this particular problem.
Richard, on
Yes.
the Arizona statute, it looks like you don't have to wait for law enforcement to approve it, right?
Well, it's not approved, but it still is a form of prior restraint, is that you're registering communications or what identity you're going to be using when you're communicating.
I think it stinks, but...
Well, okay, well, that's right. It's not an approval. Now, we will get to it and actually discuss a statute that was struck down in Indiana.
So can we get it struck down?
Well,
I'm from Arizona.
well, you need to find a lawyer in Arizona unless you're going to give me a lot of frequent flyer miles, okay?
Well, we can discuss it.
Well, we can discuss it, and like I say,
It's the same in Florida. You have to register it before you can use it.
okay, all right, well, that's what I'm saying. That is a real vulnerability in the statute. There's only so many me and Janices around, though, okay? But hopefully, you know, these kind of communications, this paper, if you take this paper back to your home state, if you're from out of state, and an issue comes up, please feel free to share it with any attorneys you know that might be willing and interested in expending some of their time doing these things. Okay. If we go to the next slide, please. Utah says within 3 business days, so generally the time deadline is the same as it is in the Arizona statute. We can go to the next one. Now, Texas is really long, and it doesn't surprise me because they apparently put a lot of thought into this. The thing that's interesting about this provision is Texas has a general 7-day requirement. It does not have the pre-registration requirement that you have to go register the online identifier before you can even use it online. But the thing that's interesting is, I spoke to you a moment ago about the fact that different statutes in different states will set out how it is you're supposed to update the information. I mentioned some states allow you to do it online, some states by mail. But generally most of them require you to do it in person. That's going to come up as a kind of an important question in determining whether statutes are constitutional or not, for reasons I'll explain in a moment. But Texas is real interesting, is that they basically delegate to the registering authority how it is they want you to update the information. I think that's kind of a can of worms. I do have a client in Wise County who has been accused of failing to update his registration, actually online identifiers. And I'm going to be real curious to find out. There's really no way of knowing. I mean, he tells me kind of that he was told he was expected to do this in person, which actually does impose a greater burden on someone's freedom of speech to have to travel to especially in large counties, go travel, take a day off or whatever, because it's going to be during business hours, and having to do that every time you change an online identifier or use an online identifier. But I really don't know whether Wise County required him, as a matter of policy, I suspect they did, that he'd be expected to show up in person to write out and give this new identifiers to the people, or whether they might give him the option of doing it some other way. I suppose you could even do it by telephone. Of course, I'm sure any authority that did it would want something in writing just for record purposes. Yes, sir.
Richard, is that just for personal use, or is that for like job, only work in school?
Well, that's a problem that you run into with these kind of things. I mentioned the fact that we know, generally speaking, that banking information, the statute's silent on it, and almost all of them are. The general idea is the category of chat rooms, email, that kind of thing would be limited to things other than banking. I don't see any clarity in whether that would apply to any kind of communications for work or not. I would tend to think that, and that's one of the problems is when you have statutes that are vague like this, it has a chilling effect, and it causes people who are expected to comply with it to over-report. That is, they're reporting more information than the statute reasonably could expect them, because, the idea is that, and we're going to mention this in a minute too, the government really has to have some legitimate objective in imposing these requirements. They can't just do it because they think it's a great idea and not just because they got the power to do it. But different states, and Texas we're going to get to the problems with the Texas statute. Most states, in defending these statutes, will say it's solely for the purpose of law enforcement being able to assist them in investigating crimes that have been committed, okay? And that's actually the justification the U.S. Supreme Court used for not striking down the general registration requirement with your address and where you live and where you work and that kind of thing, is that it actually makes more efficient the apprehension of people after they've committed a crime if they're sex offenders. But as we'll see as we go through this, in particular the Texas statute, it's not limited to that objective. You've actually got, and as we're going to talk about, they've got a system in Texas set up where they disclose this information to Facebook if Facebook asks them, or MySpace, or any other commercial social networking site. They provide the information to them for free, and although it's clear from one of the cases we'll discuss that it would be unconstitutional to ban outright a registrant's access or use of the internet, and especially if they're not on probation or parole, and that's generally where you run into it, is people like my clients at Doherty's. Mr. Doherty's not on parole, he's not on probation, he's required to register for, and like all registrants, you have to register in Texas either 10 years or for life. There's actually a statute that was struck down in Indiana that just said anybody that's a sex offender, you can't use the internet anymore. And which is just crazy because, it's based on an assumption that any person that's having to register is every time going to use the internet only for the purpose of engaging in some kind of online solicitation, which incidentally all states already have laws against. So the short answer to your question is, I don't know whether the Texas statute or these statutes we're discussing would include work online identifiers or online identifiers used in connection with employment, but I would think that they probably would, and you kind of are in a position where you have to over-report just to cover yourself. Yes, ma'am.
Well, went back to the judge, and the judge okayed that our son went on for business and school. It was not told to us that you had to go, tell anybody else about it or anything.
Okay, well, yeah, and that's what I'm saying is, and we're going to get to this, I was kind of actually at the end of the paper, is states have generally, they recognize that they can't compel the disclosure of online identifiers if that would breach someone's or anonymity when they're online. And so they have varying degrees of restrictions on what the registering authority can do with that information as far as disclosure goes. And we're going to discuss that in the different cases that have addressed it. Some of them say you can't disclose it except for, or have been interpreted to mean that you cannot, the registering authority or the DPS in our case, can't disclose it for anything other than an ongoing investigation of a new offense to other law enforcement agencies that aren't responsible for acquiring the information in the first place. In Texas, as we'll see, it doesn't have anything to do with law enforcement. They know they can't ban people from going online if they have to register. So they send all the information to Facebook and say, hey, by the way, you don't want this guy on your site, do you? So let's go ahead and you can block him that way. And it accomplishes really the same thing. Indirectly, what they could not do directly, they're doing indirectly by disclosing this information just to anybody that's a commercial social networking site. And I'm going to talk about that in a minute too. Yeah.
One maybe relatively minor point, but I've been asked by a lot of registrants when a time frame is set up, like there, 7th day.
Right.
There's the uncertainty. Is it 7 calendar days or is it 7 business days?
Okay, most of them say, well, we're on this one now. Most of them will say excluding weekends or holidays. We saw that in the last slide. Some of them will say within 72 hours, 72 business, 3 business days or 72 hours. And so most of them are not too bad about being clear about that. Texas, I don't guess, really says one way or the other. They do have a provision in Texas. I was talking about it to someone earlier this morning, is that Texas has a kind of a exception thing that it's either 7 days or when the registering authority allows you to register information. So I think it was intended to, encounter a situation, and it's whatever sooner. And so you might have, if you're in the city of Denton, you've got a guy who avoids people that leave messages for him to come in and register, who will set up appointments and then not show up for the appointment to help people register. And as a matter of fact, it came up in connection with residency restriction ordinances enacted by cities. My experience with that, without getting too far off track, is that in Denton, the way they started doing it, the same person, the same police officer that was registering people as under state law was also the person within the city responsible for enforcing the residency restriction that had been enacted by the city. And so my clients would go in to register, and he would see that your residence violates our city ordinance, so I'm not going to allow you to register your address under state law, which is a felony, whereas the city ordinance is a ticket, Class C misdemeanor, $500 fine. What I realized when I first heard about this is there is a provision in Chapter 62 of the Code of Criminal Procedure in Texas that says the time does not begin to run until the registering authority allows the person to register. So what happens is if somebody goes in to register and the officer says, I'm not going to let you register because you would be violating our city ordinance, the time never begins to register. And so you never have to register, okay? And I let that go on for a little bit, and then it kind of made me a little nervous about people when we were getting indicted without me telling them what was going on. So I called this captain and said, hey, I just want to thank you. My client wants to take you out to dinner. And he goes, well, and he's saying, well, what are you talking about? And I said, well, you won't allow him to register under state law because it would violate your city ordinance. He goes, that's right, I'm not going to allow him to register. And I said, well, you know what that means, don't you? And he says, no. I said, my guy doesn't ever have to register as long as he lives in Denton then, right? And he's going, what are you talking about? And so I printed out and scanned and emailed to him the provision of the code highlighted. And he called me back. He said, well, I don't know what we're going to do about this, but we're going to do something. So you just tell your client we'll be in touch with him or something. I said, fine, And it took him about a month talking with the city attorney, and then I finally got a call back from the chief of police in Denton saying, oh, there's been a big mistake. Here's what we decided we're going to do is we're going to go ahead and allow your clients to register, even if their residence address would violate the city ordinance. But we're going to give them a ticket right there on the spot. And I said, well, okay, fine. I said, that will actually save me a lot of cost in a civil lawsuit, because when you convict them of that city ordinance, then I can appeal and get it struck down that way. And so I said, well, okay. And so after that, the next time I actually had a client that got one of those tickets, and I went in, the municipal prosecutor, who's really a nice woman, she dismisses every one of them, because she says, look, we don't want to get sued. We don't want to lose an appeal like this. Just go away, okay? And so they really don't, at least with my clients, if I'm involved, and I haven't talked to too many other lawyers around about it, but I'm assuming that most of the time, if not all the time, she dismisses those tickets for violating. But it is kind of interesting, because we're talking about the deadline for doing something. Under Texas law, the time doesn't begin to run until the registering authority allows you to. Okay, can we go to the next slide? Okay, and keep going here. What we're talking about here is something we mentioned a minute ago about the degree to which the registering authority, and I guess probably the DPS who they communicate the information to, the degree to which they are permitted or not permitted, consistent with your First Amendment right to anonymity, to disclose the information, your online identifiers in this case, to third parties, including other law enforcement agencies that aren't responsible for registration or acquiring the information, or even social networking sites online and others. We can go to the next slide, please.
Can I ask a question about what is meant by online identifier? For instance, Facebook knows me because of my name plus my password.
Mm-hmm.
But if you go out to find me, the only identifier you need is my name. So are they looking for the name I use, or are they looking for name plus password?
Well, basically the idea is, on the theory, and like I say, I don't really buy the theory, but the governmental interest in requiring this, theoretically, is when they are investigating a crime. Say some teenage girl says, this man solicited me to have sex, blah, blah, blah. He used this name in the chat room or in the instant messaging program. The idea is that a law enforcement investigator who had a screenshot or whatever, or maybe the girl wrote it down or printed it out or something, he would be able to, from that information, track backwards and identify the true identity of the person who was using that handle, okay? And that is seen, and generally, that, the court's almost a consensus of the court saying that is a legitimate use and a legitimate reason for the requirement that people report to a central agencies what handles or online identifiers they're using online, okay? And as we know, if anybody's got a Facebook account, you don't really have to say who you really are. And you can register it using an email address that doesn't necessarily say who you really are. And then, of course, if they really get technical about it, they're going to probably have your URL address so they can get an idea of what computer terminal you're using when you're going online and appearing or communicating in these online chat rooms and instant messaging. I'm not sure whether that answers your question, but...
Well, I just was curious if you have to report every time you change your password.
Okay, well, as I said, they use the term change a password, or it's not a password, it's changing an identity, or a name or nickname or whatever you want to call it. And you're not really changing a nickname, you're acquiring a new identity, okay, online identity. So, for example, when you go in and register for the first time, you give them the email address that you are using or have used or intend to use in the future. later on, you may decide you like Yahoo better than Hotmail. So you establish a new email address, and you're not really necessarily changing. I mean, I know that I've got probably email addresses that I haven't looked to see if I had any mail in from 20 years ago. I think I'm pretty sure I've got a Yahoo email that I just don't use. And it'd be kind of interesting to see what kind of mail I've gotten in the last 15 years.
So you're thinking that you don't have to report passwords?
They're probably going to want, I'm not sure about the passwords. They might want to have the passwords. I mean, I know a lot of employers, for example, that's been an issue where employers want your passwords to Facebook so they can see what secret pictures you got on your account and that kind of stuff. Of course, that's a non-governmental entity, so it doesn't really reach, in that sense, a First Amendment thing, which only restricts governmental action. But you know, it's, from what I can tell, it's not talking about passwords, these statutes. They're just talking about the public persona or name that you're using for the purpose of tracking it back. It's not a tool to get into. Of course, the thing is they probably could, through subpoena, get your password from Facebook if they tracked
There
you.
actually have been a lot of cases where they did actually include passwords, but they've been so unanimously defeated so quickly in court that they've kind of settled down on including passwords. But as I was going to mention, guys, we're kind of throwing things off track, and you get to kind of hold your questions to the tail end, keep things going.
And it'll be a little more coherent, I think, this way.
Explains.
Okay, the California statute that we're actually about to talk about here in a minute, it was actually struck down. Although we're not talking about Fourth Amendment privacy, where you'd have to have probable cause to do that or reasonable suspicion to do something else. When you're talking about online anonymity, you're still dealing with a privacy issue and a reasonable expectation of privacy, because when you're using a pseudonym online, generally there would be a purpose. You'd have a reason not to disclose who you are because, as I mentioned before, you're afraid of retaliation. You're afraid of what you're communicating not being considered in the same way that it might if your true identity were known. And the question comes up whether, if the legitimate purpose of requiring the disclosure of this information to the government is so that the government can then use it to trace a crime that's a new crime that's committed on the internet back to you, you would seem to think that there would be some threshold requirement that the investigation be based upon some reasonable suspicion that a crime has been committed and some attempt to identify an individual for whom there is reasonable suspicion to believe they've committed a crime. That's kind of an emerging area. Whether it's necessary for that to happen or not is not really clear. And as I say, there's only been about 4 or 5 cases that have addressed the constitutionality of online identifier statutes. We can go to the next slide, please. With regard to the scope of what is constitutional for these governmental entities to disclose the information to other people, the Utah statute was really ambiguous, is that it starts off saying that it's the purpose of the disclosure, that it's okay if you disclose the information if it's to assist in investigating kidnapping and sex-related crimes and in apprehending offenders. And then elsewhere in its statutory scheme it says, or one of these other purposes, and start citing all these other purposes that have nothing to do with the initial statements. And then the craziest thing down here is then it says, okay, or if the record can be used to produce a public benefit that's greater or equal to the individual privacy right of the person it protects. What in the hell does that mean? You know? And who decides that? You know? Who decides? I mean, I've got a privacy expectation. I mean, that basically lets an individual officer or an individual policymaker of each registering authority kind of decide on their own who gets more points, your privacy or whatever they can dream up as a reason to disclose the information to a non-public, or actually a public third party, or even a private third party. If we can go to the next slide. California, this was a statute that was struck down by the Ninth Court of Appeals last November. Janice has stepped out. I called to ask her a couple of months ago whether the California Assembly had amended its statute. As y'all know, Texas actually had its online solicitation statute struck down, and there's a big scramble in Austin to try to amend or enact a new statute to cover that. I suspected probably something like that would be going on in California. In California it is?
We're going to be protesting it in Ohio.
Okay, well, I guess it was probably, Janice, you remember me calling you about whether the California Assembly was amending the online identifier statute that was struck down? Yeah, I think you told me at that time they weren't doing anything. I guess something's changed on that.
They have introduced a bill now, the Senate Bill, 448.
Yeah.
And, yeah, they would make anybody register their internet identifier within, I think it was 5 days, Pam?
They changed it from 3 to either 5 or 7,
Right.
and they were more specific about chat rooms as opposed to just in general. So
Yeah.
they're trying to take the decision, there are 3 points.
Yeah, there's I'm going to discuss
Right.
2 of the problems the Ninth Circuit had about it, but one of the problems is that the California statute, as it is written here, it says, they can disclose it to whoever they want if it's necessary to ensure the public safety. And the Ninth Circuit Court of Appeals, as we're going to talk about this case, said that doesn't give any guidance to a law enforcement officer to know, what's in the interest of public safety. It's just so generic. It could be up to the complete discretion of a governmental authority to decide when the stuff can be disclosed. It also creates a corresponding concern of someone who is having to disclose this stuff, is you don't really know the circumstances under which your identifying information is going to cause the breach of your anonymity, because you don't have any guidance any more than the people who are responsible for disclosing this stuff. I mean, if you just say, well, gosh, I guess I can go online and use my new handle on Facebook because I guess they won't think that it's necessary to ensure the public safety that be disclosed. But it's so ambiguous, you don't really know what it means. Could we go to the next statute? Now, Texas, this is what I was talking about before, about this Facebook deal. In Texas, they've got this crazy thing, and I haven't seen it anywhere else, where they say that on request of a commercial networking site, the Texas Department of Safety may provide to the social networking site all public information, which is okay, that's kind of public information anyway. But this last part, it says, as well as any online identifier established or used by the person who uses the site, is seeking to use the site, or is precluded from using the site, okay? And so that's how Facebook is getting your information and blocking you guys from getting on Facebook, is routinely, I'm sure Facebook and some of these other online social networking people, if for no other reason than their lawyers are telling them to do it, they request from the Texas Department of Public Safety a data so that they can identify people that might be on their networking sites that are required to register as sex offenders. Okay, can we go to the next slide? Okay, now we're going to get down and explain a little bit more detailed than I already have the source of the constitutional protection. As I say, this is kind of a new area of law that's still emerging. From what I've seen, there's 2 or 3 issues that are really good. I tend to think that the best foundation for a challenge is the fact that it interferes or substantially burdens a person who has to register. It burdens their constitutional right to anonymity, which is protected by the First Amendment, in the same way that people that wrote, Thomas Paine, when he wrote under the pseudonym Common Sense, could advocate basically treason without fear of retaliation. Did you have something?
Yeah, Richard, I know you're going to mention our case later, the Prop 35 case, but in California, one reason we were successful in the courts was to say on our own website, we're a plaintiff in the lawsuit, so on our own website, we have people making comments all the time about a court decision or a new law that's been passed or a newspaper article, and they rarely use their own name, right? And so that, in fact, it would
Sure.
be
Sure.
really attached to
Yeah, exactly. And Janice makes a good point. I think I mentioned it briefly. The Constitution doesn't just protect people who say things that they have a right to say from, being convicted of a crime if they say something that, for example, depending on the content, the government doesn't like or does like. It also protects or prohibits statutes from being enforced that would have something called a chilling effect, okay? And when we're talking about, it's true generally, but it's also true with regard to someone who wants to maintain their anonymity online. If they know information, their online identifiers that they're given to the DPS for the limited purpose of investigating new crimes, if they know that that information is going to be distributed for reasons unrelated to the investigation of new crimes, or just because it's in the interest of the public welfare, or because some cop somewhere thinks your privacy doesn't outweigh or weighs less than some general public purpose he has in mind, it's going to cause a chilling effect on your desire or motivations, I guess, to go on to exercise your right to be anonymous and to go online, because you know that as soon as you do that, there's a good chance that your identity is going to be disclosed or discovered. Okay, if we can go to the next slide. I've given you a couple of Supreme Court quotes that kind of describe this. An author's decision to remain anonymous, like other decisions concerning omissions or additions to the content of publication, is an aspect of the freedom of speech protected by the First Amendment. That's pretty straightforward. Can we go to the next one? I think this particularly applies to people that have to register as sex offenders. Of course, it says that anonymity is a shield from the tyranny of the majority. It thus exemplifies the purpose behind the Bill of Rights and the First Amendment in particular, to protect unpopular individuals from retaliation and their ideas from suppression at the hand of an intolerant society. I don't have to tell you guys that we on occasion have to deal with intolerant members of society who kind of think that anybody who has to register is the absolute worst kind of sexual predator, predator of children. My dad was an attorney, and when he was an attorney, it was kind of, if you were a lawyer, you did everything from wills to real estate to criminal law. He did mostly criminal law. Of course, he did everything else then. Lawyers don't really do that anymore. They generally specialize. But people often ask me about kind of what it was like having a dad as a lawyer, and it was different for me because my dad would have clients that could not afford an attorney. So he would kind of take them into our family to some degree to let them work. We had a farm. They could work on the farm. And so I grew up, as far back as I remember, being around people who were, to other people, from the perspective of outside our family, criminals, okay? Felons, burglars, drug dealers. Not too many of them were violent, because my dad kind of did screen who he let hang around, but he didn't have any problem with felons generally. And I, having gotten past, I never had that kind of tunnel vision that I think most people in society do, that when they think of someone who's a convicted felon, or they think of someone who's been convicted of burglary, or they think of someone who's been convicted of a sex offense, they think the absolute worst possible thing about them, and they put a black face on them where they're not really human, okay, in their imaginations. They're offenders, they're people to dislike, and that kind of thing. And so I learned growing up that everybody's different, and some people are good people and bad people, and the fact that they may have made mistakes in their life is not something that really inherently changes the fact that everyone's different, and everyone has good things about them, and everybody generally has bad things about them too. So we do have an intolerant society when it comes to that kind of stuff, and people generally, I think, that have to register as sex offenders are left at the hands of legislatures that want to keep them or ban them from going online if they could, just generally. Okay, can we go on to the next slide? Okay, we're going to talk, this is probably, I'm going to try to make this as simple as possible. If we can go to the next slide. When courts address First Amendment issues, there are going to be different criteria and different standards that apply depending on certain things, analytical tools. I mentioned to you before that prior restraints receive the greatest scrutiny and almost invariably are going to be found unconstitutional, just because it's a really fundamental principle that you not engage in prior restraint. There is something called, there's a criteria dealing with things that either are content neutral or not content neutral. The example I would give you is that some of y'all may remember the flag burning case over in Dallas. A friend of mine, Mel Bruder, was actually the lawyer that handled that years and years ago. It was during the Republican convention, I'm thinking in '84, in Dallas, that someone was arrested for violating Texas law that made it illegal to burn an American flag. They had exceptions that if you were retiring a flag, for example, you know, the American Legion or somebody from time to time will have these ceremonies where if a flag is tattered, they will have a ceremony and burn the flag. They had exceptions where that wasn't against the law, but if you were burning a flag for, I guess, reasons that to protest things that the government or some police officer didn't agree with, you could be convicted of a crime for burning the American flag. What the U.S. Supreme Court ultimately determined is that was not a content-neutral statute, is that whether an offense was committed or not had to do with the purpose or the content of the communication. And because you could be arrested and convicted if you were burning a flag to communicate your disfavor with the war in Vietnam, which is, I think, where most of these statutes originated, or in that case, some other political reason that I guess since it was at the Republican National Convention, I can't remember exactly what the reason was why the guy burnt the flag, but the guy didn't like Republicans, I guess. But that is going to create a greater scrutiny if you've got a statute that it depends on what's being communicated, whether it's illegal or not. If we go to the next slide. Now, with regard to these online identifier statutes, every case that I've seen that's dealt with them say that they actually are content neutral, is that it doesn't directly regulate what you're going to say. It's kind of who you are. You're a registrant, so you're going to be treated differently. But it's not really going into whether you're going to be soliciting minors or talking about politics or expressing communications that are approved or disapproved by a governmental agency. So, stay there. If you go back to that one before. You go back. Now, when you have a statute that's content neutral, you apply something, not strict scrutiny like you would on content-based restrictions, but intermediate scrutiny will apply where you actually have something content neutral, as the courts have said these online identifier statutes do. You got to show two things. One, that that the statute serves a substantial governmental interest, and number two, that the statute is narrowly drawn to serve the identified governmental interest without unnecessarily interfering with First Amendment freedoms. Okay? Because, as I mentioned a while ago, if the governmental interest that is argued to justify online identifiers is limited to investigating a new crime, all the courts have said that's legitimate, obviously, and obviously even preventing the commission of a new or recidivism or a new offense of online solicitation, that's legitimate too. Almost all courts have found these statutes satisfy the first component, that is that they at least arguably have a substantial governmental interest that they're attempting to further. The question, however, is whether or not these online identifier statutes, taking each one separately at a time, actually further that governmental interest without being overbroad. And what I mean by that is including protected speech or chilling the exercise of speech unnecessarily. Okay? Can we go to the next slide? Okay, that's what I just said. Is if you're justification is to apprehend sex offenders suspected of new crimes. That's a substantial governmental interest. Next one. And as I just said, the real fight in these things, and like I say, this is an area of law that's just beginning. It's probably going to go on for another 5 to 10 years, maybe not that long, but cases are percolating up. It really is going to go on the second question of whether there's a substantial burden that's just really not necessary. Okay, if we can go to the next slide. Now, another criteria for analyzing the constitutionality of online identifier statutes raises the question of whether the internet is a public or private forum. The Supreme Court in First Amendment law has recognized something called a public forum. It knows that what they say from time immemorial, people have expressed political views on a public sidewalk or a public street or at the community market, things of that nature. Then you started getting things where the line was not quite that bright. I recall, back when I was in law school, there being a case dealing with a shopping mall. Is that a shopping mall wanted to restrict and in some cases prohibit who could be in their malls handing out literature, okay? And I think probably at the time the concern was people were getting bugged by Hare Krishnas at the malls, okay? And so these malls would come up and say, okay, we'll let you hand out everything as long as you're not one of those crazy Hare Krishna people, okay? And then there was a lawsuit. And because the First Amendment protected the handing out of literature, the real salient factor is whether or not the inside of a shopping mall, even though it's private property, was nonetheless still a public forum that required even greater scrutiny or greater justification by whoever it was that was trying to restrict speech. And what the Supreme Court did in that case, I think ultimately what they did is first of all they determined that's a content-based restriction, okay, is that whether something was prohibited or not had to do with the content of the speech. If you're Hare Krishna, you can't do that. If you're not Hare Krishna, you're selling vacuum cleaners, you're okay. And so that placed a greater requirement of justification for that content-based ordinance that restricted that. What they ended up doing, I think, in that case was kind of split the baby and said, as long as you stay in a designated area or inside of a booth and you're Hare Krishna, you can hand out stuff, but you can't chase people up and down inside the mall. So anyway, so the idea is, in this context, what the question is whether or not an online communications on the internet, chat rooms, instant messaging, blog posting, things of that nature, whether that is a public or a private forum. Can we go to the next? The Supreme Court has kind of actually gone back and forth on this. There is one case where the Supreme Court strongly doesn't use the word public forum, but says that First Amendment protections apply. There's no reason not to apply them equally to speech expressed on the internet, and kind of strongly implied that the internet is a public forum. Certainly, generally speaking, it is as much of a public market or a public street that from time immemorial has been a public forum where people exchange ideas about politics, about art, about what's going on every day, history, all those things. And so it's easy to see why most courts, and in fact most courts have determined that the internet is a public forum. And if you reach that conclusion, that's going to impose a greater burden on a government that wants to limit or restrict someone's access to communicate information on the internet. There is actually some courts that have said that even, and this is going to be probably the hairy thing about it, is if you got, I keep mentioning Facebook, if you've got a social site like Facebook that actually wants to limit who has access to it, does that change the internet communication to a private forum where there is no strong recognition of speech as you would have in a public forum? And some courts have actually said that even blog pages and even places like Facebook, where the privately owned website has a desire to limit who they let in, they will say that they still are public forums, even though that private entity has discretion to restrict, edit, delete, or prohibit posts. The idea behind that is generally, and of course this kind of raises the reason why people would want to maintain their anonymity if they knew that if the Facebook knew they were a registrant, they'd block them or kick them off. The idea is that everybody knows that Facebook, at least initially, lets anybody and everybody that wants to set up an account on their page do so. And the only thing that changes that, generally speaking, I know Facebook probably has some other rules too, but generally speaking in our context, the only reason why they're restricting what otherwise would be the general public is they don't want registered sex offenders on their page. But like I say, there are some courts that have directly dealt with it that says it doesn't make any difference in addressing this issue. If they've thrown it open to the public, just like a shopping mall throws its premises open to the public, it's going to be a public forum, even though the authority or the private entity controlling the forum does have discretion who to keep out. Okay, can we go to the next page? Now, we've talked a little bit about before is the Supreme Court has talked about timing. Generally in First Amendment law, you've got approval of statutes or ordinance that reasonably regulate the time, manner, and place of a communication. So, noise ordinance, for example. If you're like me when I was in undergraduate school, you went to a lot of loud parties, okay? And you had a lot of people hanging out in people's front yards, backyards, on the roof, everything else. And cities will often have noise ordinance that say, okay, you can do all that stuff, but not after 9 o'clock or not after midnight or whatever. That is a time, place, and manner, is that you might be able to get away with having parties like that before 9 o'clock, but because of the timing of the assembly and the communication that causes a nuisance to your neighbors, it's reasonable to regulate the time of that assembly or communication. Can we go to the next slide? And no, go back. You went to, go one back. We talked about the fact that Arizona's statute requires you to disclose the identifying information before you can even use an online identifier. That's what I was talking about, prior restraints. Those almost always are going to be found unconstitutional. On the other hand, the Supreme Court has said that requiring someone to disclose their identity and therefore breach their anonymity when communicating speech is generally going to be allowed if the information that's disclosed is only later going to be used to allow the government to trace a speech back to its source. That's the situation I've talked about already over and over, is that if you're investigating a new crime, it's not impermissible under the First Amendment for information to be accumulated beforehand so they can go back. And that's, once again, that is the reason, the primary reason why the general registration statute was found to be constitutional by the U.S. Supreme Court in Smith versus Doe and other cases, is that the idea is it's you get somebody's name, residence address, so that when you're investigating new crimes, you can go back and use that information to solve a new crime, okay? And generally those are going to be okay, so it's kind of a timing deal. Can we go to the next slide? All right, that legal distinction, it may seem a little confusing to you, but basically that is going to be one factor, and that is when the person is required to self-report his information. And whether or not the information that's reported is going to be or could be disclosed for more than government use or for some reason unrelated to that purpose of investigating new crimes. Okay, can we go to the next? All right, this is something that I think probably everybody kind of would understand. It's kind of common sense. The Supreme Court in a variety of cases, whether it has to do with Fourth Amendment privacy or speech, has kind of a three-tiered situation. If you're in prison, you have a diminished protection under the First Amendment to receive books. I know most of my clients, I know the Denton County Jail, you can't hand-deliver a book to them, even if you're a lawyer. But maybe you can if you're a lawyer, but the public at large generally, in order, if you've got a family member or a friend in the Denton County Jail, the book has to be sent directly from the publisher under seal, and that's something that obviously would not be constitutional if it applied to someone who was not in prison, or even someone on probation or parole. So you've got people in prison have probably the most diminished protections under the First Amendment, for example. People on parole or probation have more First Amendment liberties than people in prison, but are still subject to a diminished First Amendment protection in relation to people who aren't on parole or probation at all. The California Ninth Court of Appeals, Federal Circuit Court of Appeals, actually expressed in the case we're going to talk about that people who aren't on probation or parole flat out enjoy the full protection of the First Amendment. Okay? That's something, and I don't know how many, I heard that somebody was talking about the Doherty case earlier in this conference. That's something I'm dealing with this lawyer on the other side constantly, is that he seems to think that once you've been convicted of a sex offense and that forever after you've got some, even when you're not on parole or probation any longer, you are some kind of second-class citizen and you don't have the same constitutional rights as people who have never been convicted of anything. And the fact of the matter is that's just wrong under the case law, is that if you are not any longer on probation or parole, you've got the same First Amendment rights to speech as someone who's never been on probation or parole or even in prison. And it was refreshing to see this actually put in these stark terms because because that's something that you run into a lot. Okay, next slide. I think I started getting fancy with the PowerPoint here. Okay. All right, now here are the four primary cases that kind of have been provided guidance to courts that came after them in sequence. Let's see here. I think we're about page 9. Okay. Doe versus Shurtleff is one of the early cases. It dealt with the Utah statute that we've already talked about. Although that statute, as we saw earlier, is very ambiguous as to the scope of the disclosures that it would allow, there is a principle called, or an obligation on courts to avoid declaring statutes unconstitutional if they can apply something called a narrowing interpretation or a narrowing construction. And I think probably the Court of Appeals, it's the 10th Court of Appeals, kind of went way beyond what it really should have done. But what they did was say, don't read what this statute says, just take our word for it. What the legislature really meant was to limit these disclosures to the purpose, for law enforcement purposes, and solely for aiding police in solving crimes. Well, that's not really what that statute said, but that's what the court said it was, so that's the only way it can be applied. In the Harris versus State, this is the Indiana statute. It didn't really have anything to do with online identifiers, but Indiana had this statute that said that anybody required, and I think it was probably a subset, I think they said actually violent sexual offenders, which kind of can have a very broad meaning, and include people that aren't necessarily violent, as we know. But it prevented anybody that fit that category of registrants from getting or acquiring or engaging in access to any place on the internet that was accessible to persons under the age of 18. I can't think of any place on the internet that wouldn't be accessible to people under 18. There's probably a lot of places that I don't know how to get to that people under 18 know how to get to on the internet. And so basically what it amounted to was it constituted an outright ban of people who met those criteria as being registered sex offenders. And what the court said in Harris, or the Indiana Appeals Court said is that number one, it's overbroad because you are assuming that anybody who has to register or comes within this category, that their only speech is going to be solely limited to soliciting minors. So it's overbroad in that it encompasses a whole lot of protected speech and communication, and therefore violated the First Amendment. The second thing that the court found was very similar to what the Texas court did when striking down the online solicitation statute in Texas is that there's already an offense that's on the books that punishes people for engaging in online solicitation. And the government in this Harris case, Harris versus State, there's two of them, unrelated, but the Indiana case is that the government just could not show that banning everybody really accomplished anything more than what was already accomplished by having a statute that penalized online solicitation. The Ninth Circuit case we've been talking about is Doe versus Harris, and as some of our experts up here on the front row told you, there's actually 2 or 3 reasons why the California statute was struck down. Number one, they had this 24-hour requirement that you notify the registering authority within 24 hours after establishing or using a new online identifier. And what the court said was that's just, that's such a nuisance. Every time you're thinking about establishing a new online identifier, you've got to get to somebody within 24 hours to report it or you're in trouble. And they said that is just not reasonable, and they couldn't show that it was necessary to have that short of a period of time for reporting it. Therefore, it unduly burdened someone's free exercise of online anonymity. The court did apply the intermediate level of scrutiny. And then, of course, the court was talking about some other things. It was vague. The vagueness of it, as we were talking about whether employment identifiers have to be reported. If you don't know exactly the scope of what you have to report, it has a chilling effect, and you tend to either over-report information that's not really necessary, or you just don't go on the internet at all to engage in expressive speech, which by itself would establish a constitutional violation. And then, of course, third was the scope of the disclosure that we've talked about. This California statute had this thing where policemen and whoever had the information could have the discretion to disclose it if they, in their own individual opinion, thought it was necessary to ensure public safety, whatever that means. And as we heard, they've apparently got a new statute. I'm going to be interested in seeing it. Doe versus Snyder, a very recent case, just came out this year. It's a district court, unpublished opinion so far. I gave the Westlaw site for those of you who are lawyers and get access to Westlaw. You can get it that way. This was a deal where they actually expressly said that you couldn't update your information by telephone or email or whatever, that you actually had to appear in person within 3 days to give them your new online identifiers. And the court said, like the court in the California statute said, that having to go in person is worse than being able to do it by mail, which is the case in the California statute. And therefore, even though you got 3 days instead of 24 hours when you tried to comply with the Michigan statute, because you had to do it in person, it still imposed an unnecessary burden on people to do that, and therefore was ruled unconstitutional. And the court also found that, it's not really discussed here, that it was kind of vague in the sense that it wasn't real clear, and actually I think that's the case that talked about whether banking accounts, online banking was something that would or would not constitute an online identifier. The final question is, I'm about out of time, but the question comes up for those of you who are not from Texas. You may not be as interested as others, but I wanted to look at the Texas statute, and actually, I said if you could back up a little bit. The Texas statute, as we showed kind of at the beginning, and I'll just do the talking here because I guess I left a couple of slides out, is number one, we've got this deal where the disclosure, the statute delegates authority to the Texas Department of Public Safety to, on request from a commercial social networking site, disclose what is confidential information that's only supposed to be used for investigation of new crimes. And I don't think Facebook has a whole lot of people out there investigating crimes. They just want to keep people off of their Facebook page, and that has nothing to do with whether a new crime has been committed or whether there's a need to identify someone who's committed a new crime at all. It's basically some kind of like a country club membership deal where they want to know all this stuff and only have their own people on it. Let everybody, except for a very small fraction of people who they disfavor or are concerned about appearing to favor on their web pages. I think this alone is probably enough to invalidate the Texas Online Online Identifier statute, and I do intend to use it at my first opportunity. And as I said, I do have a client in Wise County, so if anybody's watching from Wise County, you'll see more about this soon. The second thing that I see as a weakness, and this is probably a little bit closer call, as I mentioned at the beginning, the way the Texas statute's set up is it delegates policy-making decisions to the local registering authority about whether you have to update your information in person, by telephone, by email, by U.S. mail. It doesn't say in our statute. It leaves it up to the discretion of the local registering authority. To the extent, now of course we do have 7 days. We know that the in-person requirement in Indiana, the in-person requirement that said you had to do it within 72 hours was too much of a burden to pass constitutional muster. We don't know whether 7 days would make any difference. Assuming that local registering authorities will require you to take off work and do it within 7 days, you may have a constitutional problem, and that imposes such an inconvenience that people are likely to be restrained from getting or using a new online identifier because they don't want to, every time they do that, to have to make an appointment to go deal with updating their information. And to the extent that that kind of a challenge was raised, I think it would probably have some merit. It's kind of an in-between kind of thing, and it's not nearly as clear, at least in my mind, that it would violate the Constitution as the disclosure to these social networking sites that the DPS is currently doing. I'm out of time. I know Janice is up next. I'm going to try to stay here. I'm going to listen to Janice, and I'll probably try to hang around for a little bit if any of y'all have any questions, and I appreciate your attentiveness, and I'll see you around. Thank you.
All right, let's got just about 15 minutes.